Well, I think we'll go ahead and begin. Looks like everybody's here. Justice Shea will join us shortly. There he is.
I'll give your attention, the Honorable Justices of the Montana Supreme Court. This court is now in session.
Good morning. Thank you all for joining us on Zoom this morning. I, for one, will look forward to having oral arguments back in the courtroom someday, hopefully. This is cause number 210032, Egan Slough versus Flathead County Board of County Commissioners and the Montana Artesian Water Company. We have an order out as to how council is going to proceed, and it's my understanding that you have all worked it out among yourselves how you're going to do it, and I believe Mr. Wilson is going to lead off.
That's correct, Your Honor. Are you ready for me to begin?
You may begin.
Thank you, Mr. Chief Justice and members of the court. I'm Kim Wilson, representing the plaintiffs, Egan Slough community. We decided, Roger Sullivan and myself, that I will be presenting first on the issue of the constitutionality and the statutory legality of the initiative 17-01, as addressed by the district court in its first order, which was the June 2019 order that is in our appendix tab 2. And then Mr. Sullivan will address the zoning issues of non-conforming uses and spot zoning. And I would also point out we would like to reserve 5 minutes for rebuttal if that's possible. At the outset, members of the court, it's important to remember that 70% of the electorate in Flathead County voted for this initiative. Their right to do so is enshrined in the Constitution, Article 3, Sections 4 and 5, as well as Article 11, Section 8. And this court, of course, has repeatedly said the initiative and referendum provisions of the Constitution should be broadly construed to maintain maximum power of the people. In light of those principles and addressing the court's decision, district court's decision, and MAWC's arguments, I would like to first turn to the statutory issues that the court discussed in that first decision, the first order. First is the question of the conflict, if you will, between Sandholm and Greens. We believe that the Greens case, Greens at Fort Missoula, controls. Greens, like this case, involved a local referendum challenging a city council resolution which approved a rezoning of a discrete piece of property. The plaintiff there, like MAWC here, MAWC, when I say MAWC, is Montana Artesian Water Company, pointed to Sandholm for the proposition that you can't use the initiative or referendum process to pass or attack a zoning decision only affecting a few folks. The court evaluated Sandholm and the Greens decision at length and rejected that argument. In Greens, the court confirmed the bright line test that if a matter is legislative, it may be addressed through the initiative process. The court said, under the facts of this case, we do not need to do anything beyond interpreting 7-5-131 as including both zoning and rezoning ordinances under the umbrella of legislative jurisdiction and power of the local government. This court has not departed from that rule in the subsequent 25 years. To read Sandholm as MAWC urges this court to do would be to overturn Greens and effectively require courts to perform a fact finding on to what extent zoning decision does or does not affect the entire electorate. So we believe Greens controls. The second statutory issue is the issue the court addressed and that MAWC raised, that the initiative enacted and repealed at the same time. MAWC argued that 7-5-132 does not allow enactment and repeal in one piece. In response to that, first, 7-5-131 subparagraph 1 states resolutions and ordinances within the legislative jurisdiction and power of the governing body of the local government may be proposed or amended, and prior resolutions and ordinances may be repealed. Thus, the statute contemplates the very thing MAWC says is not allowed. Second, in that light, the district court's discussion and statement that once 1594C became law, 1594B ceased to exist, is completely consistent with the law. The third argument is whether the language has to be fully set forth. MAWC has argued that 75132 subparagraph 4B requires that I-17's repeal of that resolution required, quote, informing the voters of the commissioner's words and findings, unquote. And because it didn't do so here, it was not in compliance with the law. First, here I would point out that Resolution 1594C did set forth the operative language from Resolution 1594B in citing verbatim the following action language from 1594B, which said, be it resolved that the petition received on June 20th, 2016 be denied, and the Egan Slough Planning and Zoning District shall not be expanded. So in effect, the resolution 1594C did set forth fully the action part of resolution 1594B. But second, as the district court noted, there's no support for the proposition that the initiative must somehow contain all the words and findings of the commissioners as urged by MAWC. What does that mean, your honors? Does that mean the transcript of their decision must be in the initiative? Does it mean that all the regulations that we were incorporating had to be in the initiative? As the district court noted, that is not required. Then the district court addressed the single subject rule. The standard for single subject is where all the different parts of a statute have a natural connection and relate directly or indirectly to one legitimate subject of legislation. The act is not invalid as containing more than one subject. That's from the Merchant State Bank case that's been law for 90 years. The district court correctly noted here that the single subject is the expansion of a zoning district in existence since 2002 to include certain contiguous real property. Here, all the different parts of the statutes have a connection. The one legitimate subject of legislation is zoning, the area identified in the initiative, as the district court accurately ruled. And finally, on the statutory issues, I would turn to the question of whether this initiative essentially went beyond the legislative authority of the commissioners and was therefore not allowed. We believe that this is also a false argument. First, the commissioners are involved in every act of creating the zone. In 76-101 through 107, commissioners have their hands in every piece of that, and the zone doesn't get created under the Part 1 zoning scheme unless the commissioners adopt it. Second, the Egan Slough zoning regulations were already properly adopted by the commission, and this initiative was intended to add acreage to a pre-existing zoning district. And that is specifically allowed under 76-117. Because the acreage was added to the pre-existing zoning district, it was subject to the existing zone, the zoning regulations. And we believe that 76-117 does not support MAWC's interpretation. In closing, on the issue of statutory compliance, zoning is well within the powers granted to the electorate. On the constitutional issues, first, MAWC has argued that this violated due process. In its appeal briefs, MAWC contends that the proponents had an obligation to publicize 6 different arguments against the initiative that have been conjured up post-election. They cite that in their opening brief as well as a reply brief, pages 23 through 24. The initiative's proponents, however, had no such obligation. The Walter Meyer case that MAWC points to is distinguishable. There, the text of the voter information pamphlet of the amendment was directly opposite to what the supporters had intended. Here, of course, that's not the case. MAWC's assertion that that these 6 facts were left out and that omission is similar to the mistake in Walter Meyer has no basis in law. As the district court noted, 1594C properly set forth the resolution being reversed. Moreover, the record demonstrates that there was vigorous public debate and MAWC's owner was very much involved in it. Mr. Weaver testified that he wrote letters to the editor and otherwise publicly opposed the initiative. He took out an ad in the newspaper. He urged others to vote against it, and he campaigned against it. So to the extent that MAWC's due process claim revolves around the initiative campaign, clearly MAWC had plenty of opportunities to and did participate. Finally, MAWC persists in mistakenly relying on a line of clearly distinguishable cases to argue that Initiative 17-01 violates its due process rights by unlawfully delegating to private property owners the power to veto a use that another private property owner proposes on its property. They cite to the Williams versus Missoula County case, Shannon versus Forsyth, the Cary versus Rapid City decision, a South Dakota decision, as well as several Supreme Court decisions. But in the Eastlake US Supreme Court decision, the US Supreme Court took this issue on by saying the standardless delegation of power to a limited group of property owners condemned in Eubanks and Roberge is not to be equated with the decision-making by the people through the referendum process. The court went on, as a basic instrument of democratic government, the referendum process does not in and of itself violate the due process clause of the 14th Amendment. Clearly, this is not a delegation to private parties that is analogous to what happened in Williams. Initiative 1701 does not violate due process. Turning to the equal protection argument, MAWC argues that Initiative 1701 fails to meet the equal protection test adopted in the Yurzik decision by this court, where the court determined that the Yurzik's right to equal protection was violated because the on-site construction provision did not have a bearing on the welfare of the community. Here, in contrast, we have demonstrated that Initiative 17-01 did in fact have a substantial bearing on the welfare of the community in the record. First, the purpose of the initiative is clearly spelled out in the initiative petition. It includes reference to the originating resolution 1594A, which created the zone, in which in turn expressly incorporated 76-2-101, which of course is that this kind of zoning has to be in the public interest or convenience. The purposes of the zone of the district are further set forth in the regulation section 5, which is to protect and preserve the agricultural land in the Egan Slough area for the performance of a wide range of agricultural functions. Second, MAWC's assertion that ties to public health, safety, and welfare by the court are unfounded ignores the extensive factual record before this court in support of that issue, including compliance with the growth policy, as will be discussed by Mr. Sullivan, but also as we noted at pages 24 through 27 of our answer brief. Now, MAWC has argued that we can't identify any health or safety concerns, implying that there's been no harm or will be no harm to the environment. I would point out, however, and we have filed these as exhibits and then supplemental authority, Judge Eddy recently ruled that the two environmental assessments that MAWC relies on for this no harm, no foul to the environment position were unlawful, and she further has voided the DEQ permit. In sum, zoning accomplished by Initiative 1701 is protective of the public health, safety, and general welfare. It is clearly distinguishable from Yurzik and is not violative of equal protection. We will defer to Mr. McCormick and the county's arguments concerning the takings issue. And with that, Your Honors, I'm going to turn this over to Mr. Sullivan unless the court has any questions.
I have one question for you, counsel, in regard to your argument on the Greens and Sandholm cases and the distinctions there.
Yes, Justice Rice.
You know, in Sandholm's, we seem to have almost constitutionalized this geographic test or this geographic inquiry. And then Greens came along, and maybe not to the same extent, but it certainly acknowledged that same inquiry with regard to the geographic impact of the proposed zoning regulation. And I'm wondering, do you see a need to overrule or correct any of those cases in light of your argument today?
Justice Rice, I think that's a good question. And you know, as anyone reading those two cases together, you kind of struggle with what's going on. I think in Greens, the court set a very bright line and said, this kind of action, zoning, creation of a zone or rezoning is legislative. That puts it into the box, the category that is contemplated in both the Constitution and 75131. I think Sandholm talks about something that's different, a special utility district, or I'm not sure I have the word right, but a special district where there's assessments done. I think that the cases that followed Greens, that cited Greens, are Priest versus Whitehall and Phillips versus Whitefish. And I think both of those cases, this court was very clear in kind of carving out and making sure that there was a distinction between administrative actions and legislative actions, and that administrative actions, such as was the case in Priest and Phillips, would not trigger the initiative process. But I think here we have a decision that was a decision to deny a zone that is being challenged by his initiative. That's clearly a zoning, that's clearly a legislative act that we are challenging, and we think it falls squarely within Greens.
The water company argues that these are two separate inquiries, but both need to be made. So you would disagree with that? I guess we're calling them MAWC.
Yeah. Yeah, because as I read Sandholm, I think it seemed to me that the court's reliance ultimately was on the fact that this was a special district and was not a legislative act. And I think that's the distinction here. Greens, I think this court made crystal clear that if it's a zoning related decision, the people get to vote on it by initiative.
And that's dispositive. And that would be dispositive. Yeah.
Yes. Sorry, Justice Rice.
Thank you.
Correct. Thank you.
Good morning, Your Honors. We submit that applying the correct standard of review is critical to resolving the issue of whether MAWC's proposed industrial water bottling facility is a valid non-conforming use under the Egan Slough Zoning District regulations. Montana's courts construe zoning regulations as a matter of law, and when construing zoning regulations as a matter of law, the judge is to ascertain the substance contained therein and not to insert what has been omitted. Here, the zoning regulations provide in section 14.1 that if a lot or building is being used in a lawful manner that was non-conforming at the time of the adoption of the regulations, then it may continue in the manner and to the extent that it existed or was being used at the time of the adoption of the regulations. Here, the district court relied on section 14.1 in conjunction with section 14.3, which addresses the circumstance of a building permit having been issued before the zoning became effective, and ruled that the phrase may continue means that after the June 21st, 2018 effective date, the regulations permitted the continued, quote, preparation for water bottling and permit acquisition, which allowed, quote, through completion of the water bottling facility, a future use intended but not completed when the regulations became effective. But that's not what the regulations allow. We submit that sections 14.1 and 14.3 make perfect sense when read together. No one disputes that the prefab building is grandfathered under section 14.3. What differentiates sections 14.3 from section 14.1 is that while section 14.3 does not include the explicit requirement of section 14.1 that the building is, quote, being used in an otherwise lawful manner, end quote, that is because there is no use being made of the building provided for in section 14.3. It has not been completed. Conversely, the proposed operation through acquisition of required permits and through completion of the industrial bottling operation inside the building violates section 14.1. In that regard, there are no facts in dispute. As proposed, MAWC's industrial operation did not exist prior to June 21st, 2018. MAWC had neither produced nor sold commercial quantities of water because, as Mr. Weaver testified, quote, doing so would be breaking the law. He did not have required permits at that time, including the wholesale food license from the state. Nevertheless, through completion of the water bottling plant, MAWC intends to eventually operate the bottling plant 24/7 and eventually produce up to 1.2 billion bottles of water per year. But these future uses did not exist at the time of the adoption of the regulations. it is equally important to note what words are not contained in the non-conforming regulations. They do not include such terms as prospective scope of the water bottling operation as used by the county planner, nor the extent through completion of the water bottling facility as used by the district court. Grandfathering the future use of a property based on such terms would require the fabrication of a judge-made test that is contrary to the plain language of the regulations. As noted, the district court interpreted section 14 to allow for continued preparation, including permit acquisition, but the non-conforming use regulations in section 14 contain no such provision. Significantly, the conditional use regulations in section 12 of the regulations do provide that if, quote, the applicant can demonstrate and maintain a continuous effort in securing state or federal permits, then the conditional use permit would not terminate. Clearly, when the drafters intended to provide that continuing efforts to get a project operating would extend deadlines, the drafters did so for conditional uses. Just as clearly, there is no such provision for non-conforming uses, and it is not the function of the court to insert what has been omitted. We submit that Russell v. Flathead County provides compelling authority here. The Flathead County regulations governing the zoning district in Russell are almost identical to the regulations at issue here. With both, the non-conforming status runs with the lot or building and is not affected by changes in ownership. Notably, the shop building at issue in Russell existed pre and post zoning regulations, but that fact did not provide a carte blanche as to what use could be made of the building. Instead, the Russell court relied on the limitations in the regulation identical to section 14.1 in holding that the regulations required maintaining the status quo of both the manner and extent of the pre-existing use. The same result should be reached here. I'll turn now to the issue of the reverse spot zoning. In Helena Sand and Gravel, this court instructed that the—
Well, before you get there, Mr. McGarvey, what are your contentions, if any, regarding the fact that the district court has revoked the permits from DNRC and DEQ?
Well, again, Your Honor, that just goes to the issue to demonstrate that it wasn't a lawful use at the time that the zoning regulations came into effect. There were other permits that were required in order to be in lawful operation. And so that just further buttresses our argument that under section 14.1, you remember that it says if there is an otherwise lawful use being made, then it may continue. So I think it speaks to that, Your Honor.
So in terms of the dates, I apologize, but I didn't look. Were those district court actions taken prior to the issuance of the permit here, or?
Yeah, Your Honor, to get the chronology here, the district court in this proceeding made its ruling prior to, and that would be Judge Allison, and that would be prior to Judge Eddy's decision under MIPA and Judge Seeley's decision under the Water Use Right Act permits.
Okay, thanks.
Yeah.
Mr. Sullivan,
yes.
I want to follow up on some of your comments there. It seems to me that your argument here ignores this language in 14.3 that clearly contemplates, with respect to reference to building permits that have previously been issued, that building has not been built. Obviously, there's no existing use in place until the building is built. there's no fact question on this record as to what that building permit related to. And so I really don't understand the argument that somehow these other permits that have to be acquired from the various governmental entities to permit the use independent of the zoning regulations, how that's material here at all.
I agree, Your Honor. I don't think it is. And we have argued that throughout. What is material is what's provided for in section 14.3 that provides that addresses the fact situation where a building has not yet been constructed. And that's why it doesn't further speak to a lawful use being made of that building, as does section 14.1. That is the important and operative distinction that we think should lead to the same result in this case, Your Honor, that this court reached in Russell v. Flathead County.
Okay, thank you.
And with that, Your Honor, I'm going to be very brief with our spot zoning. We think that the Helena Sand and Gravel case explicates what the standard is, and we think that the touchstone as to that standard is really whether or not the requested zoning substantially complies with the growth policy. We have demonstrated on the record that it complies both in terms of the land use map. We have a map that we've submitted. I would direct your attention to tab 7, page 2, which demonstrates that the expanded zone and the existing zone are both overwhelmingly rural agricultural and rural farmstead. There is no rural commercial, let alone rural industrial in that area. Moreover, the textual provisions of the growth policy, we have documented over 20 important textual provisions in which there is absolute compliance with the proposed expansion and the growth policy. And obviously, I think that the North 93 neighbors instruction here is right on point, which holds that an expansion of an existing zone does not constitute spot zoning. And with that, Your Honor, we'll reserve our remaining time so that Mr. Wilson can rebut. Thank you, Your Honors.
Ms. Marcus.
May it please the court. My name is Vicki Marcus, and I'm honored to be here today representing Montana Artesian Water Company. I'll begin with some background, then I'll argue our cross-appeal issues, focusing on the 6 different ways that I-17 is illegal. For the remaining cross-appeal issues, we rest on our briefs. We incorporate the county's arguments on whether Montana Artesian is a legal non-conforming use. I am joined virtually today by Ms. Laurel Weaver, the president of Montana Artesian, and Mr. Lou Weaver, the vice president of Montana Artesian. First, some background. Montana Artesian is a classic mom and pop operation. It's a small business. And the property being used for Montana Artesian, like most of Flathead County, has been unzoned for as long as anyone can remember. The Weavers have and continue to operate the land as an agricultural business with both livestock and farming. The land is served by an artesian well with naturally flowing water, and is explained in the final order on the water right. If the well casing was extended above the ground, the water would rise in the casing 28.8 feet above the ground. That's in our 12.5 appendix, tab 2, exhibit B, page 10. That's a lot of water, and it's a development opportunity, one that Lou and Laurel began investigating more than 25 years ago. They did this right. They took the time to go through all of the permitting and regulatory requirements. A timeline of those development milestones appears in the court orders and in Flathead County's zoning decision. But it doesn't show the full story. Like every mom and pop operation and every small business, there's a lot more elbow grease, hand-wringing, planning, and just plain hard work that does not translate well into a timeline. As this project proceeded with permitting and construction, some of Lou and Laurel's neighbors reacted viciously. Now, the business was initiated in 2014, and in 2016, the opposing neighbors began ramping up their opposition. That's when their zoning petition to the county commissioners was denied. At that point, this became an all-out war against Lou and Laurel and their business. You can see this reflected in the materials provided in our 12 sub 5 appendix at tabs 3 and 4. In there, you will see emails to Lou and Laurel calling them vulgar names, asking what's it going to be like living in an area where your whole family is hated and despised, telling them to get out of Montana and hoping that they, quote, take a dive soon, end quote. That's in tab 3, exhibit C. You'll also see public radio interviews with appellant Amy Waller telling voters to just keep in mind that it's the size of Montana Artesian's water use permit that matters when they vote on I-17. Appellant Yes for Flathead Farms and Waters publicly distributed flyers and posted signs along roads and elsewhere. That's in our tab 3, exhibit H. In this litigation, appellants have tried to couch their intention as protecting the area or protecting agriculture. But if you look at all of their statements and materials that they use to promote I-17, it is only in terms of protecting things from Montana Artesian. A good example of this is found at tab 4, exhibit I, showing appellant Yes for Flathead Farms and Waters large banner on the side of a bus telling the public to vote for I-17, quote, for protecting our water from the bottling plant, end quote. In 2018, a public boycott of Montana Artesian was requested through.
Excuse me, I don't think there's any dispute about the vehemence, and I think I would agree with you and your clients that a lot of the rhetoric here was certainly not civil, and there's a lot to be criticized about that from your client's standpoint. But this seems to me to be the classic thing that goes on in these communities with zoning decisions that are controversial. And I don't understand what the vehemence, however uncivil, of the opposition to this, what its legal consequence here in the context of the issues that are before this court. Could you connect that dot for me, those dots?
Yes, Your Honor. Specifically in terms of the illegal reverse spot zoning argument, as you're aware, the third prong of that analysis is whether the zoning resembles special litigation. Here, this is the hallmark of special litigation. No one disputes, as you noted, Justice Sandifer, that I-17's purpose was to shut down Lou and Laurel and their business. That is a hallmark of special litigation. It easily satisfies the third prong of the spot zoning test. The other reason it matters.
You mean special legislation?
Yes, I'm sorry. Yes, Your Honor.
So you're not contesting that this was a legislative matter?
No, I'm not, Your Honor. And that leads to my next point is the question here is not whether voters can zone by initiative. We're not saying that. And we're not questioning whether this was an administrative or a legislative act. That's not the issue before you here today. The question is whether this initiative is legal, and it is not. And that puts us squarely in the universe of the Euclid case, where the US Supreme Court held that the test for validity was whether the zoning is, quote, clearly arbitrary and unreasonable, having no substantial relation to the public health, safety, morals, or general welfare, end quote. That's from Euclid at 395. And Justice Sandifer, this goes straight to your point. The only purpose of I-17 in the zoning was to shut down Montana Artesian. There is no connection to public health, safety, morals, or general welfare.
Just a second. I think that's a misunderstanding of what the question or point I was trying to make. I don't think the record supports that. I think that you point out that I think what it does support is that certainly the impetus for this was the reaction, fair or unfair, and I'm not making any judgment about that, but the impetus for this was the adverse reaction, however widely felt or however fanned by people who were directly affected by it, to Montana Artesian's project here. But the reach and the language of this initiative, or the impact of it when you extend the zoning district under the pre-existing regulations, far exceeds any narrow application to Montana Artesian's operation. Wouldn't you at least concede that point?
No, Your Honor, there's been no reference to any public health, safety, morals, or general welfare. And the area that's being expanded does not resemble the original district at all. In fact, it's a zoning district made up completely of non-conforming parcels. Not a single parcel in the expanded area meets the 80-acre minimum required by the zoning regulations. Most of those lots have homes on them, indicating scattered intrusion of residential uses. And ironically, this is the one land use that the regulations called out that they sought to avoid. This is in the statement of purpose and intent in the zoning regulations. They did not want scattered intrusion of residential uses. Well, here you've added an additional expansion area that is nothing but scattered intrusion of residential uses. And not a single lot meets the 80-acre minimum. So here you have 6 independent bases for concluding that I-17 is illegal. And doing so means that you don't need to reach the issue on grandfathering, and you don't need to reach any of the constitutional issues. The first bases are on state laws. And as this court said in the Marcy's Law case, which is Mako versus State 2017 MT 267, this court said that any attempt to amend the fundamental law in violation of self-imposed restrictions is unconstitutional. That's at paragraph 12. In that case, the self-imposed restrictions were constitutional violations. In this case, the self-imposed restrictions are state laws enacted by our legislature. I-17 must comply with those state laws. Now, section 7-5-131 affirms that the powers of initiative and referendum are reserved to the electors of state government. But resolutions and ordinance may only be repealed or amended in the manner provided by statute. One of those statutes, 7-5-132, allows electors to enact, repeal, or amend an ordinance or resolution. I-17 violates this law because it both repeals and enacts a resolution in just one initiative. Appellants' only argument on this issue and the district court's only reasoning is that it made sense to do the actions simultaneously, or as the district court said, as one arrived, the other became history.
Counsel,
But the court,
excuse me again, I want to ask you about that because I'm confused by that argument as well. It seems to me that the prior resolution, which then you now are characterizing as having been repealed by the initiative to expand the zoning district. The prior resolution, at least as I understand it, and if I'm wrong about this, please correct me, was essentially a decision by the Board of County Commissioners rejecting a request to expand the zoning district, which then the initiative tried to circumvent. But that prior resolution in rejecting the request or proposal to expand the district by its own language did not purport to prohibit any future expansion of the district through a valid legislative process, whether that be in front of the Board of County Commissioners or by initiative. So I don't see that it actually, the initiative repealed anything. It just took a different position. Could you tell me why that's, my reasoning on that is wrong?
Your Honor, there's no doubt that the initiative sought to get rid of Resolution 1594B. That's the previous resolution. And this leads to the second violation of state
Let me
law.
stop you there. How did it get rid of it? All they did was say no. The Board of County Commissioners said, no, we're not going to do this. So
Your Honor,
you're not repealing anything when you get down line in time and decide for whatever reason, whether it's by initiative or the board, to go ahead and expand this. I don't understand that.
Your Honor, the resolution did more than just reject the petition. The resolution provided that the county commissioners unanimously agreed that the expansion, quote, may not be required by public interest or convenience, end quote. Those are the words in Part 1 zoning in the statute, 76-2-101. That's a threshold finding that has to be made for the petition to proceed to zoning. So there's no question that I-17 sought to overrule and repeal that decision by the county commissioners. And the voters were never.
Respectfully, that's just not accurate. That was a rationale that the Board of County Commissioners put in their resolution as to why they didn't want to approve and act on this proposal to expand, because the board in its discretion, as it saw the facts and circumstances, didn't feel that it was in the public interest. But I don't see how by any means that can be viewed as any determination by the Board of County Commissioners that they might reach, or the citizens might reach by initiative, a different view of that down line.
Perhaps they could have, but the voters needed to be told what they were doing. And the petition itself, which is found at tab 6 of our appendix, provides the petition. And in there, you won't see any reference to Resolution 1594B. And you won't see anything that tells the voters that they're repealing it. The ballot itself says nothing about repealing a resolution. The petition says they want to rescind the resolution, but it doesn't tell the voters what they're rescinding. The voters were never told that their county commissioners went through and scrutinized and did this analysis and said that it may not be required by public interest or convenience. And there's a state law that says that resolution must be set out fully. I-17 clearly does not meet that state law. The third violation of state law is violation of section 7-5-131. Resolutions must be within the legislative jurisdiction and power of the governing body. Here, the governing body is the county commissioners, but the county commissioners have no power to adopt a development pattern for a zoning district. Only the Planning and Zoning Commission may do this. I-17 does the work of the Planning and Zoning Commission, and therefore it reaches beyond the voters' authority. This leads to the fourth violation, which is the single comprehensive subject violation. Now, appellants have argued the merchant's case, and that's right. In the merchant's case, this court said that they must relate to one legitimate subject of legislation. But here there are at least two subjects of legislation. One does the work of the county commission, and the second, which is impermissible, does the work of the Planning and Zoning Commission. And this is really important in Part 1 zoning, because the question isn't whether the county commissioners were involved at every stage, as appellants told you. The question in Part 1 zoning is, were the affected landowners involved? The Planning and Zoning Commission is made up of the county commissioners and other county board members, plus two affected landowners. And that's important. Part 1 zoning seeks to carve out a distinct zoning district that affects certain landowners and treats that area in a special way. But the Planning and Zoning Commission is the only entity empowered, and it shall be its duty, that's what the statute says, to make and adopt a development pattern. That's at 76-2-104. The Dole case tells us that for each zoning district, there must be its own development pattern. And here, the expansion area is not the same as the existing district. The parcel sizes are much lower and it has different uses. Therefore, it needs its own development plan that can only be done by the Planning and Zoning Commission. The county commissioners cannot do that. If a development plan is not adopted, the county commissioners may void the zoning district, but they cannot go in and make the development pattern. The uniqueness and importance of the separate parts of Part 1 zoning, particularly the actions required by the Planning and Zoning Commission, were articulated by this court in Montana Wildlife Federation v. Sager, 190 Mont 247. In that case, this court recognized that the constitutional validity of Part 1 zoning was sustained by the definite outlines and limitations of the statutes. Here, those definite outlines and limitations of Part 1 zoning were summarily skipped. Again, in Helena Sand and Gravel, this court went through the trouble of describing in detail the steps of Part 1 zoning. That's in paragraphs 9 through 12. It included multiple hearings, staff reports, and considerations by both the Planning and Zoning Commission and the county commissioners. This court upheld the zoning despite obvious gerrymandering by the petitioners, but only because the county followed the Part 1 statutory requirements, and only because, quote, the record demonstrates that the county heard and considered public comments from both sides at all stages of the decision-making process. That's at paragraph 24. That's unique to Part 1 zoning, but here there are no stages and there is no public decision-making process to support the legality of the zoning because all of the distinct requirements of Part 1 zoning were skipped. And practically speaking, those distinct steps were important because the expansion area is very different from the original area. A lot has changed since 2002. Their lots are smaller and there are more homes in the area, which is contrary to the very purpose and intent of the Egan Slough Zoning District regulations. I-17's blanket obliteration of the statutorily provided steps destroys the constitutionality of the zoning and overrides the Planning and Zoning Commission, which is impermissible. Therefore, it violates the single subject requirement of 7-5-132, subparagraph 4A. The fifth basis for finding I-17 illegal is found in the Sandholm case. Now, we're not asking you to overturn Sandholm or Greens. Appellants could have gone through the statutory steps of Part 1 zoning, which require involvement of the affected landowners and the county commissioners, but they chose not to do that. Instead, they went straight to the voters and asked more than 25,000 voters to make a decision that affects 25 landowners and 1 commercial business. Both Sandholm and Greens involved city zoning that, like I-17, skips the involvement of the local landowners, skips the local government, and it's for the sole purpose of zoning 1 discrete district. Sandholm and Greens tell us that such a vote is only legal in the very narrow circumstance where there is an established history of public use or social significance attached to the property being zoned. We just don't have that here. Lou and Laro's property and the property throughout the expansion area, there's no history of public use. In fact, all the land has been in private ownership, excluded from the public for as long as anyone can remember. And there's no social significance attached to the property in the expansion area. So the narrow exception in Greens does not apply here. Sandholm tells us that I-17 is illegal. Now, the sixth basis for finding that I-17 is illegal is spot zoning. The first prong is whether the requested use differs significantly from the prevailing use. As I've already talked about, the requested use is to protect agriculture, and the zoning district regulations do that by preventing scattered residential intrusion and establishing a minimum acreage size. Here, the prevailing use in the area violates all of that. There's scattered homes and not a single parcel, and that's undisputed. Not a single parcel meets that 80-acre minimum lot requirement. So without a doubt, the first prong of spot zoning is met. The second prong is whether the area is small. and this can be measured in terms of landowners affected or the acreage. Here, there's no doubt that there's a small number of landowners affected, as this court held in Helena Sand and Gravel, when just one landowner is affected or one commercial business. That satisfies the second prong. Even if you look at this in terms of acreage, I-17 took 550 acres from a sea of 368,023 acres of unzoned property and dumped it into an existing zoning district. That too is small. Appellant's preferred comparison of comparing the existing zone to the expanded area is not based on any law, and it does not make sense. Such a comparison would always allow spot zoning to be legal, even just for 1 acre. The third prong we've talked about, resembles special legislation. And appellants have admitted that the purpose of I-17 was to prevent Montana Artesian. So there's no doubt that this was special legislation. All 3 prongs of the spot zoning test are satisfied here. They're giving a very strong case for finding I-17 illegal. After 25 years of planning, considering, deliberating, and building and working some more, Lou and Laurel faced a county of misled voters who would, quote, do whatever it takes to shut you expletives down, end quote. That's at tab 3, exhibit C. That is the vitriol and the hostile climate created and propagated by appellants. You'll see many of the same types of comments on their Facebook post provided at tab 4. I-17 cannot stand because it violates 4 laws. It violates case law articulated in Sandholm and Greens, and it's illegal reverse spot zoning. For our remaining claims, we rest on our briefs, but we note that any constitutional analysis must begin with the view, which is correct here, that I-17 is illegal zoning, and none of the constitutional protections inherent in the zoning process are grafted onto I-17, because I-17 does not comply with any of those zoning statutes. Was not intended to protect anything. It was only intended to stop Lou and Laurel from operating their bottling facility. For the issue that appellants bring to this court, they cannot meet their burden of proof under the abuse of discretion standard. And speaking briefly to the issue about the water right and the environmental review litigation, the water right was appealed, as you know, sent back to Judge Thiele, and it's again on appeal before this court. The environmental review case is ripe for appeal, but the timeline for appealing that decision has not yet run. So we asked this court, if you were going to rely on any of those decisions, to wait until those decisions have been appealed and briefed and decided. But you don't have to do that. You don't have to reach the appeal issue or the constitutional issues, because I-17 is illegal by the plain words of the statutes, Sandholm and Green's case, and because it is illegal reverse spot zoning. Thank you.
Mr. McCormick for the county.
Thank you, Chief Justice. I'm Alan McCormick, representing the Flathead County entities. And I thank you for this morning for the opportunity to present to you. And this is obviously a case of unusual posture for zoning. Typically, a zoning case that's brought before you is one that is an action that's been taken by a city council or a county commission. And we don't have that here. We have a situation here where the zoning was enacted by referendum. Very unusual situation. I'm unaware of that ever happening before. And so it's legally, it may not have much difference in effect, but in practical terms, this is a situation not created by the county commissioners or an action that they took. And in fact, as Justice Sandiford mentioned earlier, the county commissioners had previously denied a request to expand this zoning district for a variety of reasons. I'll start first with addressing what Mr. Sullivan talked about, which is the grandfathering issue. Section 14 of the Egan Slough Zoning Districts is the section that we need to turn our attention to. Section 14 has 6 sections to it. Each one of those is disjunctive, And that's critically important in evaluating and applying the rules of statutory construction and the rules for interpreting zoning ordinances. Section 1, which plaintiffs and appellants point to, is a section that deals with existing uses and structures. If it existed and was in operation at the time the zoning ordinance was enacted, Section 1 controls. Section 2 is a very different subject. Section 2 addresses the situation of what happens if you stop that use after the enactment of the zoning regulations. How long do you have before it's voluntarily abandoned? Section 3 is the situation that applies here, and Section 3 deals with the situation of what happens if you have a building permit issued, but you haven't even begun construction. Do you get to continue, or are you have to putting aside your building permit and not allowing to construct the building and to construct the use? Section 4 deals with changes. What can you do if you're a non-conforming use after the enactment of the zoning regulations? Can you expand it? Can you make modifications to it? How much can you expand it? Section 5 addresses the situation of what do you do if the structure is damaged? Can you rebuild it? Can you replace that structure? And finally, Section 6 deals with unsafe conditions. It specifically says that if nothing in this ordinance is intended to prevent you from doing something to your building to address an unsafe condition. Obviously, those are all disjunctive provisions of Section 14. They have to be given independent review. And the situation that we're dealing with here is Section 3. Very importantly, and in contrary to the appellant's argument in trying to bring in the provisions of the non-conforming or the conditional use permit, Section 3 deems that any building for which a building permit has issued is a non-conforming use. So the text of this regulation specifically contemplated that you would consider not only the structure that had the building permit issued for it, but what use would that building be put to? And there simply isn't any question in this entire proceeding that the building that was being built on this property was being built specifically for the water bottling facility. All of these efforts to try to enact the zoning regulations, to challenge the beneficial water use permit, to challenge the surface water permit, all of those predate the enactment. So everybody knew, of course, that this was going to be the water bottling facility. And Section 3 addresses
Mr. McCormick, just on that point, do you think that's a critical factor in determining whether Section 3 applies here? I mean, what if the intended use of the building hadn't been known? Does that matter?
Justice Baker, I think it could matter, certainly. If someone was building a prefab building simply for the purpose of using it for something, and it was not known what the use is, how could you determine what that building could continue to be used for? That's why Flathead County conducted an investigation. And as part of that investigation, it asked what the use was for. Of course, everybody knew what the use was for. And that is certainly within the realm of the context of saying, not only in Section 3, 14.3, that it is a non-conforming structure, but specifically saying it's a non-conforming use, because a structure in and of itself is not a use. So certainly I believe the county would have taken into consideration some other use. And no one is arguing that should Lou and Laryl Weaver decide to convert this building into some other use, that they're allowed to do that. They're not, because the non-conforming language gets triggered at that point, and they cannot change the use to something else because of those provisions. I'd like to turn now to the takings argument. Montana Artesian makes a couple of points in their brief that I want to specifically address. But first, I want to ask a question. And this question demonstrates the fallacy of Montana Artesian's arguments. That question is this: even assuming there is a taking, how much of their property was taken? It's a question no one can answer. And no one can answer that because their sole allegation of harm and taking is related to a beneficial water use permit, which they technically are correct. Statute defines as a water right. But it is a permit that allows them to use up to 710 acre feet. And they have 20 years to figure out whether they're going to get there. But they did not build a facility that was capable of using the entire water right. They cannot do it at this point by their own admission. They have a septic system that does not allow for that use to be maximized at 710 acre feet. And we simply don't know what they're going to use until they file a notice of completion. At that point, the notice of completion will establish how much water they're using at the time. And that's important. It's important because what they're arguing here, and take a look at what they argued down below, which is because of the regulations, if they are not allowed to utilize all 710 acre feet, the permit is entirely void. And that is simply not true. There is no fact that supports that conclusion. And in fact, the language of the permit that they have specifically states that at the time they file a notice of completion, the amount of the water right will be perfected as to the amount that they have actually used at that point. So how much is being taken? What property interest is being taken by these regulations? Montana Artesian points to one bit of evidence. It's an affidavit from Lou Weaver that has a statement in it that says, under the existing equipment configuration, they can't maximize the use of the 710. What MAWC says is that the county failed to provide evidence to contradict that statement. But that is not the standard for summary judgment proceedings. That accepting that to be true would be to mean that we are required to accept as fact and conclusive evidence a statement in an affidavit. What the district court is charged with doing, and what the district court did here, is take a look at the body of evidence. And the body of evidence shows that that statement from Mr. Weaver is the sole evidence in support of their claim that their property right was taken. But it is a conclusory statement that is refuted by the other evidence that's in the proceedings. And for that reason, the district court was perfectly eligible to discount the validity of it. It's also a hedge. It's a hedge that under the present configuration of the equipment, we can't maximize it. And so the county, of course, challenged the validity of that so-called evidence by saying, what about different configurations? What about other things that might come up? In their beneficial water permit and their applications for that beneficial water use permit, they mentioned that they wanted the right to use up to 710 acre feet. And that would be incremental over time. It would be subject to market demands, would be subject to contract needs, would be subject to any number of things that have yet to occur. And the point of saying all of that is this: speculative harm does not give rise to a taking. Thus, the point of my question, which cannot be answered because they do not have a 710 acre perfected water right that has been taken. And so there cannot be a takings under the Penn Central test because the investment-backed expectations have not been completely eliminated. In fact, there's no evidence that they've even been materially harmed. There is only a statement from Mr. Weaver that there's a potential harm, and that is insufficient to create an argument for a takings under the Penn Central test as adopted by the Supreme Court. I see that my time is up.
Rebuttal then is Mr. Wilson, is that correct?
Mr. Wilson, I hope you know you're on mute. You're muted.
Thank you, Mr. Chief Justice and Justice Baker. A couple of points I want to respond to. At the beginning of Ms. Marquis's presentation, she talked about the viciousness, if you will, of this campaign. We've pointed out that all the activities that are at issue here, that legal issue, were lawful. The petition was under the statutory Part 1 zoning provision. The initiative process, as we've already discussed, was all lawful. As Justice Sandifer pointed out accurately, zoning issues are controversial, and that doesn't necessarily weigh into the actual merits here. The next point I would make, again, going to a point that Justice Sandifer made, 1594B, as Justice Sandifer pointed out, it was essentially a negative. It was a refusal to enact a zoning resolution. And so to that point, I do think it's correct to say that in fact, there wasn't a repeal and a enactment here, but we think in any event, the statute 7-5-131 subparagraph 1 allows both a repeal and an enactment. I think as a practical matter, the district court judge here was correct in how he phrased it, and I think that that's what the law allows. Ms. Marquis has also argued that there were various tasks here that should have been done by the Planning and Zoning Commission that weren't done. It's our position that 76-2117 expressly allows adding territory to an existing zone. In this case, we specifically were adding territory subject to the existing regulations. We don't think as a consequence that the decision or the fact scenario that she discussed with the dual case applies here, because here there's not different zoning regulations contemplated nor zoning sub-districts contemplated. This is simply an area being added to the zone. There's the question of in Greens, was that a unique case limited to the public interest and the past public access, as MAWC has argued? And I would point out on page 1081 of that decision, the court said, were the land to become used for a multiple of private residential housing units that are planned, the entire community could be affected by the added pressures, financial, social, and environmental. So the court was not limited to just the circumstances of public use and public access. And the court made clear at the very end of the decision, it says, under the facts of this case, we need do nothing beyond interpreting 7-5-131 as including both zoning and rezoning ordinances under the umbrella of legislative jurisdiction.
Mr. Wilson, before your time runs out, could you just
Yes.
briefly state your position on the takings issue if your position on the non-conforming use were to prevail?
Yes, Your Honor. Yes, to kind of reframe that, the question would be, if we prevail on the non-conforming use and they can't run the water bottling plant, does that change the takings argument? And our response, Your Honor, is we do not believe it does. I would point out that in the very first hearing on this case, which was the mandamus hearing, Mr. Weaver was asked about the use of the property. He was asked, does the water bottling facility limit the agricultural use of your property in any way? He responded, no. Can you still have cattle? Answer, there are some cattle being run on my property. And you can still farm? Most all the property is still agricultural, except maybe approximately 2 acres. So we think, and that's at pages 76 and 77 of MAWC's supplemental appendix, where they have the transcript from that hearing. And tied into that, Justice Baker, is the decision in Kafka. I would direct you in particular to paragraph 93, where the court said, we conclude that appellants should have reasonably anticipated that the game farm industry might be phased out due to health and safety related concerns. In other words, appellants could not maintain a reasonable investment-backed expectation that they would permanently be insulated against the possibility of this. So I think we believe, Your Honor, that given the dual track here of Mr. Weaver seeking a permit, but the neighbors seeking zoning to keep this area agricultural, we think that that dual that there's reasonable investment-backed expectations would fall more on the side of the Kafka decision here.
Thank you.
And with that, I'll be done. Thank you, Mr. Chief Justice.
Ms. Marcus. You're also on mute. Nope.
You're still muted.
Can't fault you for technical problems since we had our own technical problems to begin with.
How about that?
You're good. You're good.
Okay, I apologize. I did not mute myself, so it was something that happened within the system. So I apologize for that. I will start first with the taking issue. I-17 is illegal because it is a taking, which is contrary to the growth policy. Now, the county argues that the water right hasn't been perfected, so it's not a property right. That's not true. The water right was valid as a property right at the moment that the final order was issued. Montana Artesian, at the time this decision was made, had a valid water right for 710.53 acre feet. Now, sure, the water right could be forfeited like other rights. It doesn't mean that he didn't have a right to that volume of water. Montana Artesian has not forfeited its water right, nor does it intend to. And in fact, even if Judge Seeley has revoked or Judge Eddy has revoked the water right, that revokes the DNRC's action on the water right application, not the application itself. The application was submitted with a priority date that pre-existed the zoning. That priority date will hold when the application is approved, if it has to be reapproved. So Montana Artesian intends to develop the full water right, but it's denied that opportunity by I-17. It's forced to forfeit its water right by I-17. That's a taking. And there's been no provision for compensation of that taking, whatever volume it may be. Now, I want to talk a little bit about Flathead County's arguments on the evidence. Now, keep in mind that these were cross motions for summary judgment. And in this case, court's decision in Kilby Butte Colony versus State Farm 217 MT 246 paragraph 7, a district court must evaluate each party's motion on its own merits. So Montana Artesian submitted a motion for summary judgment on the taking issue, supported by an affidavit from Mr. Lou Weaver, the vice president of Montana Artesian. Appellants then had to, Flathead County had to respond with some concrete evidence. They cannot respond with just mere denial, speculation, or conclusory statements. But that's all you heard here today from Flathead County. Flathead County's attorney poses questions. There's no evidence to support that any of those questions is a valid concern or a valid question. None of that negates the evidence that's in the record, which is a credible affidavit from Mr. Lou Weaver. Montana Artesian had a water right of 710.53 acre feet. I-17 forces them to forfeit a portion of that water right. Therefore, I-17 is a taking, and according to the Flathead County growth policy, it's illegal. Second, I want to go back to this issue of whether the resolution, whether I-17 repealed the resolution. I-17 enacted resolution 1594C, which clearly says that resolution number 1594B shall be rescinded. That's important because you can't have both of them at the same time. So it clearly says it's rescinding or revoking or repealing resolution 1594B. When it does that, it's by law required to set out fully the text of the resolution it's repealing. It does not do that. Now, appellants argue that they're just adding land, and they point to the statute 76-2-117, but they leave out the last part of that statute, which is important. It says you can add land, but it's subject to the procedures provided in this part. That's all the individual steps of Part 1 zoning that they skipped. If the neighbors don't like what's going on in their neighborhood, they can zone it, and they can go to the county. They can do Part 2 zoning, countywide zoning, or they can go through Part 1 zoning. What they can't do is summarily skip all the steps of Part 1 zoning. That obliterates the constitutionality and the legality of the zoning. I-17 cannot stand. The Greens case says that the entire community was affected only because they were talking about Fort Missoula, which the entire community has used. The same issues do not exist here. I-17 is illegal for at least six reasons. Thank you for your time today, and thank you for your careful consideration.
Chief, now you're on mute.
Thank
There you
you. Thank you to all council. Thanks for cooperating in our now normal but still unusual process. We will consider this matter in due course and take it under advisement at this time. Thanks again.